As this court is aware, the standard is simply whether my client has raised the gist of an arguable claim. Mr. Haskins deserves the chance of an inquiry into how things went awry that led to his plea and the abandonment of a Fourth Amendment claim that we think has merit. Now, there's two issues raised in the briefs. I actually think it's easier to start with the second issue. One of the reasons I wanted an oral argument here today was because of some concessions in the briefs helps simplify things. The state, though it's inconsistent, seems to take the position that this Fourth Amendment claim could have been raised on the direct appeal. And given that, I think it should have been raised on the direct appeal. And the shortest path is for this court to look and to evaluate it as a question of ineffective assistance of appellate counsel for not raising the Fourth Amendment claim. In fact, the entire purpose of this stipulated bench proceeding was so that Mr. Haskins would have the chance to raise it on appeal. Now, before we get much farther, I think it's worth talking about what the applicable standard is here. Now, first, there's a question of how do we read petitions? And courts read them for a gist. They're liberally construed. Does the claim have a foothold within the petition? And then there's what do we read those petitions for? This is the familiar Hodges standard, which says, is there an arguable claim? In the context of this case, it's important that it's whether the petitioner is relying on an indisputably meritless legal theory, i.e. that's one that doesn't even have support in a good faith argument for the modification of existing law. It's important because I think there's a few areas, preservation in this case, on very detailed Fourth Amendment things, where the case law is unsettled. And the answer is, if the case law is unsettled, then he deserves a counsel and he deserves the chance for his claim to be heard. Now, on this Fourth Amendment claim, I want to be clear that this claim is squarely within the petition. It's important. It takes a little bit of cross-referencing, but paragraph 18 of my client's petition says that it's clear after reading the record, petitioner did have issues he wanted to preserve for appeal. Parenthetically, my client notes, he states Attorney Alexander C. Whitman's statement, stanza 8 to 11, stipulated bench trial, held 5th day of February 2024. When you go to that page of the record my client is referencing, it's page 262 of the report of proceedings. Mr. Whitman says, yes, Your Honor, for the record, we'd be proceeding on a stipulated bench trial. The defendant had some issues that he wanted to be able to preserve for appeal. And just before that, in that record, is the denial of the motion to reconsider the Fourth Amendment, the result of the suppression hearing, where the court itself says an appellate court someday may analyze this a different way, but all the different elements associated with consensual encounter were met. Beyond that, my client is also referencing generally how he had real concerns that appellate counsel didn't raise, that among those real concerns was a Fourth Amendment law. At most, maybe my client is misidentifying the point at which his Fourth Amendment law claims got forfeited or lost. But this is where I think the Thomas and Smith cases that are cited in the reply are helpful. We don't require a defendant to do the precise citation of case law. If my client is misidentifying the correct procedural vehicle by which his claim should have been raisable on appeal, it doesn't matter at this stage of proceedings. What matters is that my client did want to have this claim heard on appeal, and that was the entire reason to go into a stipulated bench trial. And so, Your Honors, once we get to this question of does this Fourth Amendment claim have merits, I think it's quite compelling. There's a number of reasons in the brief, and my predecessor counsel in her opening brief does a great job detailing out all the history of harassment of Mr. Haskins by Officer Hester, harassment of Mr. Haskins' estranged wife, all this history. But I think it's worth going to a few very detailed points because they're the shortest path to a finding of arguable merit. And one of them is, even if we say this is not a stop, even if we say it's not coercive, all my client consented to was a peek of the vehicle. Hester asked him twice, do you mind if I take a peek? And again, a peek. That word peek is something less than a full search of a vehicle. Consent to a peek doesn't give consent to a full search, let alone a search that goes into a container of an eyeglasses case, within a container of a map compartment, within the enclosed space of a vehicle. And we start to look at what this case law is would somebody reasonably interpret, at least arguably, consent to a peek to mean this sort of detailed search? Well, the case law about that word peak, and this comes up in the reply brief, is, do a search where all the federal courts saying, what does a consent to a peek mean? It's come up here and there. Is a peek is something less than a search. It's something less than a look. A peek is is a brief look or a glance. In that reply, we cite the Gooch case that talks about how a peek in the trunk didn't allow the officer to search under a trunk cover. We cite the Quintero case from the Eighth Circuit that talks about how consent to a peek of a hotel room didn't allow a comprehensive search of that hotel room. This peek issue has come up, and it's at least arguable that that consent to a peek is not consent to a search. In fact, we have cases that go both ways on just consent to a look. The opening brief, I think, focuses on this Baltazar case that talks about, well, consenting to a look inside of a U-Haul moving van didn't allow the officer to move things around and look behind the boxes and find a hidden compartment. If a look isn't enough for this kind of consent, then a peek certainly isn't enough, or at least it's arguable and it's not indisputably meritless that it's not enough. But to back up a step, given the history between my client and Officer Hester, given the history between Officer Hester and my client's wife that the opening brief detailed, there was no valid consent in the first place for this search of the car.
Counsel, if I could interrupt you and back you up just a little bit further and talk about the petition itself, though, because, when we talk about the fact that he claimed his trial and appellate counsel were ineffective, his petition did identify specifically certain items. It was not just some overarching statement about ineffectiveness. It specifically stated that they were ineffective for particular reasons. One, failing to secure information on the drug court, failing to inform the defendant of any plea offered by the state, failing to ensure the petitioner understood the proceedings were occurring and what rights he was waiving regarding agreeing to a stipulated bench trial, and failing to challenge or preserve any post-trial appeal rights by ensuring the petitioner was consulted, brought forward any issues petitioner was wanting to preserve, such as the pre-sentence, and this is where it gets specific, such as pre-sentence investigation report and his well-known history with substance abuse, and failing to set a hearing to determine whether his failure to appear at sentencing was beyond his control. It does not in any way, he's very, very specific. He does not set forth in that petition the failure to address the motion to suppress. And as you indicated, that was very prominent and even up until the point of the stipulated bench trial. But he doesn't raise that here. Why should we, even liberally construing this, why should we find that that's included in the petition?
A few responses, Your Honor. First is in that bulleted list, he does reference, and this is on C-189, the second to last bullet, he talks about failing to adequately represent petitioner throughout the proceedings, in particular, in regard to a Fourth Amendment illegal search and seizures motion already denied. My client then misidentifies what was necessary to do to preserve that. He places it in the motion to reconsider, where the state now takes the position that it could have been raised on direct appeal. But the Fourth Amendment is clearly referenced in there. It's also cross-referenced in that paragraph 18, which happens before any of these sentencing things in the record. That paragraph 18 is referring to the very beginning of the stipulated bench trial, where the state's attorney says that Mr. Haskins has things he wants to preserve for appeal. And it's clear there's going to be only one thing that it's referring to at that point, which is the denial of his motion to suppress on Fourth Amendment grounds. And then beyond that is that paragraph 18 is also part of what comes up in paragraph 12 on page 187, where it talks about appellate counsel failed to address real concerns the petitioner had related to the proceedings. Now, this is where I think the Thomas and Smith cases that are cited in the reply are helpful. All the claim on appeal needs some relationship to what is raised in the petition. And my client is certainly raising a Fourth Amendment claim, and he's certainly faulting appellate counsel for not developing that Fourth Amendment claim and getting it to this court, even if his procedural understanding is a little bit mistaken. I also think the Smith case from the First District, it's very helpful because it surveys the case law as to what exactly, when is an underlying claim and a claim of counsel's ineffectiveness linked. And it says that the summary of the case law results that there need not be a, quote, precise linkage between those claims. I think there is a precise linkage here because he's citing the page of the record by paragraph, he calls them stanzas, where that linkage is made. So I would suggest given the way we liberally construe petitions, it certainly is referring to the possibility that Fourth Amendment claim was on appeal. It's especially the case because the entire point of these proceedings, the entire point of doing a stipulated bench trial was to make that claim heard for appeal. And, I think it's briefly worth talking about issue 1 in the petition because, the first issue of the petition raises this question of whether he actually had preserved the claim for appeal, whether there was a preserved defense. And the Illinois Supreme Court has been fairly clear that that a stipulated bench trial is tantamount to a guilty plea if the defendant does not present or preserve a defense. Given that the defense was not preserved, even if that lack of preservation happened because of appellate counsel's failure or happened because of a motion for a new trial, that is the Illinois Supreme Court's plain language, at least arguably support the idea that that something went awry here. And, the state makes the argument as well, there was an effort to preserve it and then the preservation sort of maybe went away at some point. But this court has been clear. It's been very skeptical to this stipulated bench trial proceedings. They often risk, quote, a miscarriage of justice from this court. Other courts talk about how precise procedure must be followed. My client went into the stipulated bench trial. He didn't believe he was pleading guilty, but he had the result as if he pled guilty, and he lost the ability to have that Fourth Amendment claim raised. And frankly, I think this warrants an inquiry as to exactly how this kind of error happens. Now, I'd be happy to answer any questions from the court, but I'd ask that this court reverse the dismissal of my client's post-conviction petition and remand the cause for second stage proceedings.
Counsel, if I can ask the question in your argument or in your opinion, do you agree that the defendant never conceded that the stipulated facts were sufficient to convict him?
I would have to, in terms of that two-prong statement from Galarza, is no, we're talking about the second of those prongs, whether there's a defense that is preserved. It was not intended at the time to be a stipulation that the evidence is sufficient to convict. It was intended as to be a stipulation as to the facts. So under that two-prong framework that the Illinois Supreme Court has set out for when a stipulated bench trial is tantamount to a guilty plea, there's an internal fight on issue 1 as to the first prong, which should be whether there is a preserved defense.
And it seems to me part of what you're arguing is that defense counsel's failure to file a timely post-trial motion challenging the suppression issue then was something we should consider in whether his stipulated bench trial was tantamount to a guilty plea. How would defense counsel's action after the fact be relevant to that inquiry?
Well, I think this comes up in the reply as well, is it's often the case that at the time of the stipulated bench trial, we don't know yet, a court doesn't yet know if a defense is preserved. The Galarza case, for example, looks to counsel's sort of closing argument to determine if there's a defense preserved, even though all those admonishments would have happened well before the stipulation. And I also think, at least arguably, it's a natural product of the Illinois Supreme Court's language. It doesn't ask when the defense was preserved or not. It is whether. And then one more response is this language as to the necessity of a post-trial motion. This goes to the Cregan case. It's been controversial for years whether a post-trial motion is actually necessary to preserve a motion to suppress. If we look through this body of case law, we routinely see the state bringing up, even in cases where that Cregan rule would apply, that this constitutional claim was not preserved because there wasn't a post-trial motion. And the fact that the state continues to argue it certainly suggests that it would be arguable. However, Your Honor, I think the more natural path here is to say that there was at least arguable merit to this Fourth Amendment claim. He's referring, the whole point of the petition is to try to get back to where he was before that stipulated bench, before that appeal where he lost the chance to have that Fourth Amendment claim. The whole purpose of the stipulated bench trial was to have that Fourth Amendment claim heard, and that's clearly the gist of this petition. And given that that's the natural reading of the petition, or at least it's a way to read it liberally construed, this court should give him the chance for what he should have had on direct appeal, which is an attorney who would raise this Fourth Amendment claim so that this court can resolve it on the merits. Thank you, Your Honors.
Being no further questions, thank you, counsel. You'll have time in rebuttal. And Mr. Manchin, your argument, please.
Thank you, Your Honors. May it please the court, counsel. In this case, defendant has raised basically two issues on appeal, neither of which are before that should be considered by this court, because neither of these issues were ever raised in the defendant's post-conviction petition. Liberal reading of a petition does not rely upon the imagination of counsel later reinterpreting or restating or misstating what was said in the petition. The petition, as far as the claim that he entered into a guilty plea without warnings, the petition doesn't contain one word about a guilty plea. He just says, basically says, I did not understand what I did with the stipulated bench trial. That is not and cannot be interpreted as a claim that I was actually, that this whole procedure was actually a guilty plea and that I should have been admonished. The defendant is just simply restating or recreating or pulling out trying to bootstrap an argument that was never raised. At the same thing with the claims regarding the illegal search. The defendant's petition only does not state that anything about the a motion to suppress or anything other than that the trial counsel erred in filing a motion to reconsider because the requirements of a motion to reconsider were not present. This does not in any way, shape, or form raise the claim that the trial court was wrong in its ruling as to the decision on the motion to suppress that raised only the issue of the initial stop or seizure. Whether this was a consensual encounter or whether this was a Terry stop or whatever what happened to be. The issues of an improper guilty plea and an improper search and seizure are simply absent from the defendant's petition and cannot be read into it but under any kind of liberal construction. The plain statement that appellate counsel failed to address real concerns does not preserve these issues. The liberal construction does not absolve the defendant of presenting the details as to what the errors were. If the simple statement counsel was ineffective is enough, every single post-conviction petition filed will have to go to second stage because under defendant's theory, the simple statement that counsel failed to address real concerns raises whatever issue I imagine on appeal. That is not the standard. And when the defendant, as in this case, has a specific list of what he thinks counsel should have done, and that list does not include in any shape or form the issues he raises on appeal, those new issues should simply not be considered by this court. And I will not address the merits of the claims on regarding the search and seizure because were never raised by the defendant's brief. I will point to one thing, that if the reference to the motion to reconsider is sufficient to raise a claim of ineffective assistance of trial counsel based upon search and seizure, that claim is without merit because he in fact filed a motion to suppress that was denied. the prongs for ineffective assistance. There are two prongs for ineffective assistance: defective performance and prejudice. And failure to establish either eliminates the claim of ineffective assistance. And where counsel has in fact filed a motion, the deficient performance prong fails, and we don't need to get to the merits as to that. But I simply submit that this is a case where we're appellate counsel is using his imagination to raise issues that should have been raised or could have been raised, but were never raised by the defendant, and claiming that under a liberal interpretation of petition that is silent on these issues, the trial court was required to move to a second stage to address these new issues that were never raised. And I think this court should reject that view. Is there no other questions?
No other questions? Thank you, counsel. Mr. Eustin, any additional rebuttal?
Only that my client expressly cites in paragraph 18 the lines of the record that are important here. Those lines of the record is when the state's attorney says that they're proceeding to a stipulated bench trial because the defendant had some issues he wanted to be able to preserve for appeal. Any fair reading says the only issue at that point in the proceedings is the result of the motion to suppress. Given how we're supposed to liberally and not cynically construe these petitions, given how we only look for a gist of a claim and not a fully developed claim, I would submit that at the first stage of post-conviction pleadings, my client clearly has pled enough for this and the other claims to be in the petition, and it warrants second stage proceedings so he can get to the position he should have been in the first place of an attorney on direct appeal who raises the claim that he wanted to preserve. Thank you, Your Honors.
Thank you. The court will take this matter under advisement, and the court stands in recess.